So, you received a gun permit denial in New Jersey. That can feel like hitting a brick wall, right? But here's something a lot of people don't realize. That initial no from the police department is not necessarily the final answer. The law actually provides a clear path forward. In this explainer, we're going to walk you through that official appeals process step by step so you can understand your rights and figure out your next move. You went through the whole process. You filled out the application. You did the background check. You did the long wait, only to get a denial letter in the mail. I get it, it's incredibly frustrating, but it really isn't the end of the story. New Jersey law gives you a formal way to challenge that decision, and that's exactly what we're going to break down right now. All right, here's what we're going to cover. We'll kick things off with why a denial isn't the last word. Then, we'll dive into the single most critical deadline in this entire process, one you absolutely cannot miss. After that, we'll walk through the practical steps of filing your appeal, we'll demystify what actually happens in the courtroom, and finally, we'll talk about why having a lawyer can make all the difference. Okay, first things first. It's so important to understand that the denial you got from your local police chief is an administrative decision. It's not a judicial one. The whole system is actually designed to give you a second chance, a chance to have a real judge look at your case with a completely fresh set of eyes. This isn't some hidden loophole we're talking about. The right to appeal is written directly into state law. It empowers you to request a hearing in Superior Court, where a judge will hear your case from the very beginning, totally independent of what the police decided. You can think of it as a complete do-over. Now, we've come to what is, without a doubt, the most critical piece of this entire puzzle. Seriously, if you only remember one thing from this whole explainer, make it what we're about to talk about right now. The moment you receive that written denial, a clock starts ticking. You have exactly 30 days to file your request for a court hearing. Not 31 days, not about a month, 30. Calendar, days. This isn't a suggestion or a guideline, it's a hard, non-negotiable legal deadline. In the legal world, they call this a jurisdictional deadline. And trust me, it's as serious as it sounds. What it means is, if you miss that 30-day window by even one day, the court legally loses the power, the jurisdiction, to hear your case. Your right to appeal that denial just vanishes, permanently. There are no extensions and no do-overs on this. So let's just map this out so it's crystal clear. Day 1, the letter arrives. For the next 30 days, you have an open window to take action. But the second the calendar flips to day 31, that window slams shut. For good. Your only option at that point would be to start the entire long gun permit application process all over again from scratch. Okay, so you're inside that 30-day window and you're ready to move forward. How do you actually file the appeal? Well, getting the process started is probably more straightforward than you think. And hey, here's a little bit of good news. Thanks to a recent change in the New Jersey courts, there is no longer a filing fee for these kinds of appeals. This is a big deal because it removes a major financial hurdle and makes it easier for people to actually access the justice system. The whole process really boils down to 3 main actions. First, you've got to draft a formal, written request for a hearing. Second, you file that paperwork with the Superior Court in the county where you live. And third, this is crucial, you have to serve, which is just the legal term for formally delivering, copies of your filing to everyone who needs to be notified. So who's on that notification list? You have to make sure a copy of your appeal is formally served to 3 parties: the superintendent of the New Jersey State Police, the county prosecutor's office, and, of course, the chief of police who issued the denial in the first place. This makes it official and lets all the key agencies know that the appeal is happening. You've filed on time, you've served all the right people, so what's next? What actually happens when you get your day in court? Let's pull back the curtain on the hearing itself, because it's probably not what you're picturing in your head. This right here is the key concept. Your hearing is de novo. It's a Latin term that literally means from the new or from the beginning. The judge isn't just reviewing the police chief's decision to see if it was reasonable. No, the judge is wiping the slate clean and hearing the entire case from scratch, making their own independent decision based only on the evidence presented in court. And you shouldn't be left waiting around forever. The courts have directives in place that aim to get your hearing on the calendar within about 60 days of when you file your request. This helps keep the process moving along so you can get a resolution in a timely manner. Now, once you're in the courtroom, the whole dynamic flips. The burden of proof is now on the state, represented by the county prosecutor. This is so important. They are the ones who have to convince the judge that it's more likely than not that you are legally disqualified. At the same time, you have the right to present your own evidence, bring in your own witnesses, and, critically, to cross-examine anyone who testifies against you. After all the evidence has been presented and all the arguments have been made, the judge will issue a final ruling. They'll either uphold the denial, or they'll issue a court order that forces the police department to grant your permit. And even if the judge rules against you, it's still not necessarily the end. You have another 45-day window to take your case to the next level, the appellate division. So all these rules, these deadlines, these courtroom procedures, it all leads to a pretty critical question. Should you try to navigate this all by yourself? Now, you absolutely have the right to represent yourself, but it's really important to understand the complexity of what you'd be walking into. You have to remember, this isn't just an informal conversation with a judge. It's a formal, complex legal proceeding. Winning your case isn't just about telling your side of the story. It's about building a compelling argument that follows very strict rules of evidence and legal procedure. So what does a lawyer actually bring to the table? Well, they're experts in the rules of this particular game. They know how to gather the right kind of evidence and present it effectively. They know how to cross-examine police officers to find weaknesses in their testimony. They know how to object when the state tries to use evidence against you improperly. They don't just state facts, they weave them into a persuasive legal argument using past court cases to show the judge why ruling in your favor is the correct legal outcome. So, at the end of the day, a denial letter isn't a final verdict. It's a barrier. And as we've seen, it's a barrier that the law itself provides a door through. You have a legally protected right to have your day in court. The path forward is there. The only question left